Well, ladies and gentlemen, good afternoon. My name is Stephan Parmentier. I'm a professor of criminology and human rights at the Faculty of Law at Leuven University. And I'm delighted actually to be with you this afternoon in the company of a very distinguished lawyer and human rights academic, Professor Paul Lemmens, who's the judge, the Belgian judge at the European Court of Human Rights. So we're very pleased to have Paul with us this afternoon to shed light on the challenges for the court for the next years. In fact, the program says for the next 70 years. That's 7 long decades. So we're very curious to find out what Paul has to tell us. Please let me briefly introduce the speaker and also the topic. A lot has been said this morning already about the European Convention on Human Rights. One element that has not come to the fore is that it's often seen as the jewel in the crown of the Council of Europe, because it's a very special convention and a very special legal instrument, obviously. And if this is the case indeed, then the European Court could legitimately be seen as the diamond in that particular jewel. The court, it does not have to be repeated, but has a lot of achievements, of course, over the last decades. For example, it's the only court in the world where more than 800 million people have direct access to. And that's an absolutely unique feature for individual complaints, but also for interstate complaints. The court has established a collective guarantee of human rights in the 47 by now member states of the Council of Europe, and of course has also rendered many groundbreaking judgments to which national jurisdictions and even other international courts and bodies are referring to. And these have deep implications on the legal and social practice in many member states of the Council of Europe. But on the other hand, the court has also engendered and entailed lots of challenges. Not to speak, for example, of the length of proceedings in the Strasbourg proceedings, indeed, which may take a long number of years before the court is rendering a judgment. Or some critics argue that some of the case law, in fact, of the court has been too activist and too extensive, even in the protection of human rights. And last but not least, the many, many challenges that come our way, societal challenges. Think of terrorism and how to deal with terrorist suspects in national legal orders. Think of privacy issues, particularly in COVID times, where the whereabouts of so many people are being sought after. And of course, also cultural diversity in very diverse European states is at stake, and the court has been dealing with them and will probably have to deal with them even more. So is there evidence for hope? As Catherine Sicking, the famous American human rights scholar, has argued, or is there reason for concern? Well, we will hear from our distinguished colleague, Paul Lemmens. Paul is a professor of human rights law at KU Leuven and the founder of the Human Rights Institute at our Faculty of Law. He defended in 1987 his doctoral dissertation, particularly on a topic which at that time was quite innovative, namely Article 6 of the European Convention of Human Rights, the right to fair trial, and he did so under the supervision of a former judge at the European Court, Professor Jan de Meijer. At Paul's retirement ceremony at the Faculty of Law last year, he was called by many a man for all seasons, because he has practiced law in various capacities, not only as a judge in Strasbourg, obviously, but before that as a practicing attorney at the Brussels Bar, as a judge at the Council of State, which is the highest administrative organ in Belgium, and also as a human rights panel member of the advisory panel in Kosovo, just to name a few of his many positions and many functions. So I'm extremely pleased and very honored at the same time to be able to introduce you to Professor Paul Lemmens. And without further ado, I would like to give him the floor. Please, Paul.
Thank you very much, Stephan, and thank you very much for your most kind words, very friendly words. You gave already
a little bit louder. I think the sound is a little bit far away. If you can come a bit.
Maybe I should come a little bit closer then. I don't know.
Yeah,
can you hear
that's already better. Yeah, it's better already. Yeah.
So thank you very much for your very kind words. Also for the list of challenges that you already mentioned that maybe have been discussed this morning, challenges for the convention, for the European Court. It's a challenge for me to try to give a reply to all of that. I would also like to thank all the colleagues in Leuven who invite me to participate in this conference. You chose the right date. It's exactly 70 years ago. There's one big conference or one ceremony that is taking place today in honor of the 70th anniversary of the convention. It's during the meeting of the Committee of Ministers at the level of Ministers of Foreign Affairs in Athens today. So Athens and Leuven, we are now celebrating the 70th anniversary of the convention. Let me first say something, just a reminder about the origins of the convention, the historical context. It's important to remember that the convention was adopted in 1950, 1 year after the Council of Europe was created. And as authors of around that time wrote, there were two main reasons why the convention could be written in such a short time. One was the aftermath of the Second World War, a totalitarian regime that had turned into a deadly regime. And so the idea was we should have an instrument and a mechanism that makes it possible to sound the alarm when things go wrong in a certain country. And it should be an international mechanism because perhaps within the country it would not be possible anymore to sound the alarm. So international control to prevent dictatorship and totalitarian regimes. There was also another reason, a second one. It was the start of the Cold War. And so the Western world had to gather around fundamental principles to show that they were different from the other side of Europe, communism. Communism was a challenge. It became attractive in Western Europe, so it was necessary to have a dam against communism. And this European Convention on Human Rights at the time was a very novel instrument, not only because of its list of rights, but as we all know, because of the convention mechanism, the Commission and the Court of Human Rights at the time, which placed the individual in a central position at the international level. This was a sort of a revolution in international law. Now, let me further look at the convention from its origins until now. And the first element I would like to briefly mention is that there have been, the convention itself, the text of the convention has changed. And I'm referring to the various protocols that have been amending the convention or that have been added to the convention. Some of them contain substantive changes to the list of rights. That's already some time ago since that has happened. Maybe in the future, there are plans within the Council of Europe to do so. Maybe in the future, there will be a protocol about the protection of the environment. And it all has something to do with climate change, etc. I think it would rather than be about placing obligations on states than giving clear rights to individuals. But okay, it's not clear. Plans are there on the table, and they are, and the idea is slowly developing. Institutional changes, they have been very clear with protocol number 11 of 1994, doing away with the old system of a commission and a court, creating one new permanent court. It's a very new system since 1998 when that protocol entered into force. And another protocol that should be mentioned, protocol number 14 of 2004, which provided for the creation of the single judge formation and which gave extended competences to the committees. That's one thing. That's the work of the states parties who added protocols to the original convention. In the meantime, the European Court also started to develop its case law, and after so many years, there is a whole lot of case law. It's about human rights, of course, I will come back to that. It's about the rule of law in all its aspects relating to the legislature, to the executive, and also to the judiciary. And in particular, I would like to emphasize the role of the judiciary for the rule of law, because that is what seems to be most problematic at this time. There are a number of countries, everyone knows, I don't have to mention them, where the judiciary is under threat, and where sometimes the European Court of Human Rights has already handed down judgments insisting on the rights of parties to the proceedings to an independent and impartial judge, insisting on the rights of judges to be respected in their rights, and finally also insisting on the right of society to an independent judiciary, which translates itself most often in a respect for the separation of powers. There's also the development of the principle of democracy. I think that the European Court has contributed to setting up democracies that are not only democracies in a formal sense of the word. It's not only about what is the majority and how does the majority decide. A democracy is a much broader thing. It has a much deeper content. It's about how society functions, how society treats individuals that are members of the society. I like to say that in a democracy, in a real democracy, that individuals feel at home, that all individuals feel respected and feel that they have a place in that society. Overall, one could say that the European Court has created, through its case law and on the basis of that convention, a European public order based on certain fundamental values. I don't have to say too much in detail about these values. It's about, for instance, human dignity. And let me refer, when we talk about human dignity, it permeates the whole convention. But let me refer, for instance, to conditions in detention, conditions of detention, condition in prisons, conditions also of detention in centers for persons with a mental disorder. These are people who are not considered very important by society, but a democratic society built on human dignity should pay attention to them. And there have been numerous judgments, including against Belgium, where this has been underlined. The personal autonomy of individuals is another fundamental value to be found most of the time in relationship to or with respect to complaints dealing with the right to respect for private life. But it is broader than that. It's also about protection of the aspects of a person's identity. Equality is another value. Equality, right to equality, protection against discrimination. We have various areas here where are important in the court's case law: gender equality, racial discrimination, equal treatment of persons with a disability, etc. Also respect for persons in a minority position, and not only a national minority, but persons who for some reason or another do not belong to the mainstream. That's also part of equality and non-discrimination, and it requires sometimes positive measures from the state. There's also, there are a lot of values that I could bring together under the heading solidarity, fraternity, solidarity. We are an open society, an open democratic society where people discuss their interests with each other, where we also expect certain things from others. The whole idea of living together has sometimes been criticized because it has been used by the courts in the court's case law to say that certain people have to compromise when it comes to their own fundamental rights in order to make it possible for the whole society to live as a society, to obtain a certain harmony within society. But that applies also that, or one of the reasons is that minorities have to be protected. Individuals, as I said, must, or individual interest must on occasion be subordinated to those of the group. I think we have experienced that very well, and we are experiencing it again in a time of a pandemic, where we might have our own ideas about how to deal with it, but because of the solidarity with the group, there are obligations that we have to accept. Convention as such speaks only of fundamental rights, refers, however, in one article, the one on freedom of expression, to duties and responsibilities, and it is an indication of a more broader category. Duties and responsibilities are everywhere. They should not be exaggerated, but they are everywhere, and they can be used within certain limits as justifications to restrict individual rights. I'm stressing this because the whole story about fundamental rights, the whole story about the European Convention on Human Rights is not only about rights, it's also about that other part, responsibilities, and about the balance between rights of one person on the one hand, rights of other persons, responsibilities of the two, and also the general interest. I think this balancing is very important, and it's part of the fundamental values upon which the convention is based. Now let me concentrate in the next point on the court. Is the court able to fulfill its mission? And I think that the court has a double mission. First of all, adjudicate cases, and secondly, develop human rights law. First, is the court still able to do justice in individual cases? I would like to answer this question from a double point of view. First, from an organizational point of view, and then secondly, from the point of view of this notion of subsidiarity. From an organizational point of view, when I entered the European Court some years ago, I was really impressed by the quality of the internal organization of the court. It's a big boat. Literally, the architecture of the court is like a boat, but the court is moving very swiftly on, and it uses, for instance, informatics and so on in a way that I don't think that most of the domestic courts have. But nevertheless, the number of cases is a problem. Sometimes it is said that the court is the victim of its own success. Every year, the court receives about 50,000 new cases. Every year, the court decides about the same number of cases. Last year, it was somewhat less. There were 45,000 cases that came in, and 41,000 cases were disposed of. We have in the court at this moment, 30th of September 2020, 62,000 pending cases. That's a lot. 62,000 pending cases. If we look at what happens with the incoming cases, most of the cases are immediately dealt with by a single judge. They come in and they go out. It is the most difficult cases, or the more difficult cases, that remain pending. For the moment, there are about 22,000 cases pending before a chamber, 35,000 cases pending before a committee, and only 5,000 cases pending before a single judge. But during the year, the single judges have done a tremendous amount of work. What do these figures mean? One, a huge number of incoming cases means that there is a continuing demand coming from all over Europe. Second, most of the cases are dealt with by the single judges. They do not require a lot of energy and resources from the court. Third, a high number of cases pending before committees. It means that many judgments, earlier judgments of the court, have not been properly executed. There are too many repetitive cases still coming to the European Court. And finally, the fourth element is a high number of cases pending before chambers. These are more difficult cases, cases that require according to the current standards, a more in-depth examination by the court. And from the court of view of the court's backlog, I think that these 2,000 pending cases are in fact the most problematic ones. I can tell you that the court is now reflecting at the end of the process of reform of the court, the Interlaken process. I will come back to that. The court is currently reflecting on ways to deal with these numbers of cases, especially the chamber cases, an adaptation perhaps of its priority policy, so as to reduce the number of cases that will go to chambers, but not limit them only to urgent cases or cases dealing only with the core article of the convention, but look at other cases, non-urgent cases, but that may be very important for the country concerned or for the convention system as a whole. I'm thinking, for instance, of about Article 6 cases, which have been somewhat left out of the system, not completely, but they did not get the same priority in the last years as, for instance, under the old court. Maybe Article 6 cases will come more before the chambers because they are important for domestic judges. And the bulk of the other cases, thousands, 10,000s of other cases, would go to committees of 3 judges, where they would be disposed of in a very expeditious way with shorter judgments and shorter decisions. That's what we are going to try to do. Let me say something about subsidiarity. Subsidiarity is not something new, but it's a buzzword nowadays. Since a number of years, governments insist on subsidiarity. It's something that the court used and referred to already in one of its very first judgments. It said that it has a subsidiary role, and in taking action that relates to the convention, national authorities have a margin of appreciation. Why is that? Because national authorities are often in a much better position than the European Court to deal with interferences with human rights. Is it necessary to interfere with human rights? And to decide to what extent an interference is necessary. But of course, the question arises, how does the court control what is done at the national level? As the court used to say and still says, the margin of appreciation goes hand in hand with European supervision. The second part of this pair, European supervision. It is said that the court nowadays applies a process-based review. What does that mean? And does it lead to lower standards of protection of human rights? I think a process-based review contains mainly 3 aspects. One, a control of the procedure. Did everything go the right way? And in particular, did those who were involved in the decision-making process, did they have an opportunity to make their view known to the deciding authority? That's not a big issue. Secondly, control on the reasoning of the domestic authorities and the justification they have given for the measure that they have adopted. And this is not purely procedural anymore. This is about the substance. This is, in fact, about whether or not the domestic authorities understand the convention, whether they apply the principle of the convention in a correct way, whether they pay attention to all the relevant elements to come to a balanced solution. Do they search for a fair balance between individual rights and the general interest? Very often, the European Court has to conclude that the national authorities did not properly weigh all the relevant elements in the case. To just give you one example, last week in a Turkish case about freedom of expression involving the main opposition leader in Turkey, who had said certain unkind things about the then prime minister, now president of Turkey, Mr. Erdogan, and for that reason had been ordered by a civil court to pay damages to Mr. Erdogan. The European Court said, but there are a lot of elements in this case that have not been taken into account by the court. The political context, the fact that this was a matter of general interest, etc., etc. And so the European Court found what I would then call a procedural violation. It's not about the outcome, it's about the process. But, and that's the last element, ultimately, the European Court also exercises substantive control on the outcome of the decision-making process, on the decision itself. The court is and must remain the final arbitrator. It is not hiding behind the process. It's not a purely it's not a pure control on the reasoning only. Ultimately, it will be for the court to decide, for instance, whether or not an interference with human rights was proportionate. Where the process, the decision-making process was defective, it is not necessary for the court to go that far. And national authorities can resume their work, do it again, perhaps come to the same conclusion, that's possible, but then on the basis of a better analysis. Sometimes the court does not look into the quality of the decision-making process because it's so obvious that the result is utterly unacceptable, manifestly disproportionate. This happened also with, to give one example, with a recent case, again involving freedom of expression in Turkey, this time with respect to the freedom of two academics, two university professors who had been the target of various reactions following the publication of a report in which they had played a role. Criminal proceedings had even been brought against them. They had not been convicted, but they were under threat of a conviction for many years, which had a chilling effect on them and probably also on other academics. And here the European Court came to the conclusion, even bringing criminal proceedings for academic speech does not meet the pressing social need, is not a proportionate interference to certain legitimate aims that may have been pursued. So here a violation of Article 10 on a substantive point. By the way, a boost for academic freedom in this case. In fact, this whole decision-making or this process-based review is aimed at incentivizing national authorities to do what they have to do, to engage with the convention, to take up their responsibility. The convention rests on teamwork between the national courts and the European Court. Real teamwork. Real teamwork presupposes mutual trust. The European Court must be able to put trust in the national courts. So they also have to show not only that they engage with the convention, but that in general that they are also independent and impartial courts. We know that that's a challenge for certain countries, that there are problems with the independence of the judiciary. And in these cases, the European Court will not be able to put all the trust in the work of the courts. Let me turn to very briefly mention the point of the effects of the court's judgments. The proof of the pudding is in the eating of it. How relevant is the court? How much are its judgments being implemented? When it comes to the execution of the judgment of the court, it's a somewhat mixed mixture. Most of the judgments of the court are implemented. It may take time, but most of the time there comes an end to the implementation process, and the Committee of Ministers that supervises the execution can conclude by saying the state has done its job, the Committee of Ministers has done its job in supervising, we can close the file. There are, however, some problems with structural issues that may exist in a country. There sometimes are also political problems where the government or the parliament has some difficulty, real difficulty, or is making a difficulty in finding solutions that comply with the judgment of the European Court. We know, for instance, in Russia that there has been this law and now also the constitution that says that the constitution has primacy over the convention, and that the judgment of the European Court that would require measures that would violate the Russian constitution cannot be executed. This law has been applied twice. I would say if you carefully read the judgments of the Russian Constitutional Court in these two cases, they are not really closing the door to the execution of the judgments. They are closing it very much, but they are leaving certain openings. And in one of these cases, the opening has been used and a kind of a solution has been found, which was approved by the Committee of Ministers. The other case, and I'm referring to the Yukos case, is a bigger problem where at this moment there is a big deadlock between Russia and the Committee of Ministers. I should also mention that when a country, a state is really not doing what it has to do with respect to the execution of judgments, that there is the possibility for the Committee of Ministers to refer the issue back to the European Court of Human Rights. It has been used once, this procedure, in a case against Azerbaijan, Mammadov versus Azerbaijan, and the European Court handed down a judgment in May 2019, finding that Azerbaijan did not execute its judgment in which it had found that the detention of an opposition leader was illegal, was based on nothing of a serious suspicion. After the judgment, it took some months before Azerbaijan took the necessary steps. It was in the hands of the Supreme Court, which first tried to say, well, okay, let's give a conditional release to Mr. Mammadov. That's not sufficient. Then it said, okay, let's reduce his sentence. It's also not sufficient. And in the end, the Supreme Court decided what it had to decide. It quashed the conviction because in the meantime, Mr. Mammadov had already been convicted for the same reasons of which the court had said they did not even suffice for a pre-trial detention. So the conviction was quashed and Mr. Mammadov got even compensation for his unlawful detention. I could say a lot about the authority of the court's judgments. To what extent are they also followed by other states than the respondent states? Maybe others during the day have already referred to a number of these judgments. Let me just refer to one of the cases well known in Belgium, the Saldus case, that has had a tremendous influence on the daily practice in criminal procedure. But it's not all very positive. Sometimes the court also receives criticism. States in particular are sometimes very critical and complain that the court is too activist. NGOs say that the court is not doing enough and that it is too passive and that it is too lenient in applying the principle of subsidiarity. I think the court is following their a middle way. The backlash that is coming from states, from governments, from public authorities, it exists. It exists. It makes sometimes life for the European Court difficult, but it is not what I would say a majority stream within Europe. There have been attempts by various governments at the intergovernmental conferences, starting with Interlaken in 2010, Izmir 2011, Brighton 2011, Brussels was a very positive intermezzo in 2015, but then again, Copenhagen 2018, intergovernmental conferences within the Council of Europe on the future of the European Convention, where some of the host governments tried to come out with a final document that would reduce the possibilities for the European Court to review what is going on in countries. But there was never a support among the majority of the states for such steps. And in the end, all these declarations, with a few exceptions here and there, were rather positive for the court, in the sense that the states confirmed their commitment to the convention system and to the court. Nothing more than that, I must say. No positive steps reinforcing the court, but at least not weakening the court. Let me come to some conclusions. And I would like to ask in the first place, because we speak about the Convention on Human Rights, what about the importance of human rights today? You spoke about the Emeritus event that I had in 2019, and there I gave 3 reasons why I think that human rights are still important, perhaps even more important today than before. First, human rights protect each individual in society, especially those who are not in a position to defend themselves. They are protected by the convention, minorities of all sorts. Protecting those who are in need of protection is important, and it's human rights that are there for that. Secondly, human rights are one of the foundations of a society, of a democratic society. You have the human rights on the one hand, you have the fundamental duties on the other hand. I think together they form the social contract that should keep people together and that allows societies to develop peacefully. It's somewhat the golden rule. Do not do to others what you do not want others not to do to you, and vice versa. It's the idea of a social contract in which human rights play undeniably an important role. And third, human rights are also a security issue. How to avoid that minorities of all kinds feel excluded and take up the law in their own hands. Yesterday there were elections in another country. And if you see what happened in the last months, you see very well what I mean by that. How disrespect for fundamental rights turns into a big security issue. And I hope we are not going to see it in the coming weeks. The European Convention, when it was signed a few years after the World War, was based on this idea of peace and harmony. Unfortunately, we have had a number of conflicts even in Europe. And you can see that very well in the case law of the European Court, because the European Court has more and more interstate cases relating to conflicts between 2 states. Too many of these interstate cases. Some people say, do away with them. Take out the article in the European Convention that deals with interstate cases so that you do not have to deal anymore within the court with such conflicts. I don't know whether that's a good idea. The court does not have much power when it comes to armed conflicts and so on, but the court is an independent arbitrator, impartial arbitrator, that can also say, to the extent possible, what has happened and who has been responsible for human rights violations. Now, this brings me then to the question, and I will answer it very shortly. Why is the convention still important? Why should it remain the essential reference point for the protection of human rights in Europe, wording used by the Committee of Ministers in the recommendation of 2004? I think because it brings together individuals and states within that region of Europe. That's why I also think that it is important that as many states as possible remain in the system, because then they are under the supervision also of the European Court and of the other bodies of the Council of Europe. But success depends, of course, on the commitment of the states. So what for the next 70 years? I think the convention will continue to be based on the same fundamental values, that as a living instrument, it will be adaptable to new situations, to new issues. And what will probably characterize the convention is that system of shared responsibility. Shared responsibility, the teamwork that I spoke of between the national authorities and in particular the national courts, after so many years of practice with the convention, they should now know what the convention principles are. And the more they know, the lesser there will be a need for the European Convention to get involved in the day-to-day issues, but still to remain as a factor of ultimate control. The court will no doubt continue to play that supervising and standard-setting role, but like any court, it can be successful only in carrying out these functions if it enjoys public confidence. And that is not only a matter for the court, but that is also a matter for others, politicians, the media, the judiciary, civil society, academia, etc. And therefore, I think it was very good that you also organized this conference. Thank you very much.
Thank you so much, Mr. Judge. Thank you so much, Paul, for these very insightful remarks. Going back to the past and to the origins of the convention and of the court, which is very important, but also looking at the major developments over the many years and actually seeing and identifying two major routes, I would say, in which you see progress to be established and to come about in the next couple of decades. One is, of course, the internal reorganization of the court, which has led to fewer delays, despite the big caseload, which is still there, of course, on the other hand. But also one could even add the pilot judgments in a certain way that are useful in order to establish the principles and precedents to avoid too many individual complaints coming in on the same issues. And on the other hand, you also highlighted and actually emphasized this subsidiarity principle, whereby the court, of course, is a supranational body indeed, but can only work efficiently if it can relate under trust and the cooperation of states. And particularly when it comes to implementing judgments, I think that's a very important element to be taken into account. And well, if states implement duly, in fact, it's also a way of preventive lawmaking or administrative lawmaking, which could then avoid further cases to come to Strasbourg. We have little time, but still we have a couple of minutes, in which case it might be possible to address some questions. I saw one or two questions coming in. Yes, from our esteemed colleague, Jan Wouters, who asked the following question: that you mentioned at the end of your talk the standard setting role of the European Court. And he is wondering if that is not particularly or partially at least problematic, that the court would be expanding the scope of the convention, because his underlying or background to the question is, could it be that a conservative backlash in Europe, in certain countries, or even in more general terms, would ask the court to stay more to the text of the convention? So it's about the expansionist versus restrictive viewpoint on the convention itself, which is, of course, to be seen within the broader framework of the political developments in Europe. So could you shed some light on your ideas on this topic?
Yeah. Thank you for the question. Yeah, that is, of course, one of the elements that make life for the European Court more difficult now than before, because we have indeed that criticism coming from certain quarters that the court is too activist, that it is expanding the scope of the convention. I would like to engage in a discussion on specific points with respect to that complaint, because I always wonder, where is that expanded scope? The living instrument doctrine of the European Convention means that the European Court is interpreting the Convention so as to meet new challenges, new situations, new issues that did not exist at the moment when the European Convention was adopted. Let me refer to phenomena like terrorism, migration, but also changes in family relations, if you can even speak of family relations, but relations between two people, technological developments. All these elements have to be taken into account by the European Court to apply the principles that have always been the same. The principles, the fundamental principles based on the fundamental values that I mentioned are not being expanded, they are the same. What seems to be the problem is that when the European Court applies these same standards, they are always repeated in judgments. When the European Court applies them perhaps to new issues, the outcome doesn't always the outcome that certain political groups, governments would like to see. They are unhappy with the outcome. And then they say, but the court is going too far. Mm-hmm. But we are dealing with fundamental rights and fundamental principles. I think there is so much in the case law that sets that sets safety nets for domestic authorities. We are not taking the place of domestic authorities, not even in migration policy. We are saying certain things you can only do where you respect fundamental rights, but it is not the European Court. I hear that sometimes. The European Court is setting the migration policy of European states. That's a criticism that I cannot accept. So I do understand the criticism, but when we go to specific cases or specific problem areas, I'm ready to answer all these challenges. But of course, we don't have the time for that now.
Okay, well, thanks a lot indeed. It's good to know that you're willing to engage in further discussion on specific issues, because the discussion is never ending, of course, in a certain way, not only in academic terms, but also in relation to the court's case law itself. Well, I don't see any other pressing questions in the chat box, and I see that our time is actually running and is basically up. So I would like to suggest that we conclude here, but of course not without thanking you so wholeheartedly, Paul, for your participation in this important conference. It's nice to know that the conference can be held exactly 70 years after the Rome Treaty was established and was opened for signature. And for those of you who may wonder, why is the Liber Amicorum for Paul Lemmens, that was published last year, why does it carry the name Human Rights with the Human Touch? Well, you know the answer, because Paul Lemmens is deeply moved and entrenched in values, human values of human dignity. And secondly, you also highlighted the importance of connecting and coupling rights and responsibilities. And I think that's a very interesting debate, which of course should also be taken forward in the years to come, because human rights without the other side of the coin, without the responsibilities, do not mean a lot, neither at the international level nor at the national level. So thank you so much again for being with us in the context of this major conference. And I would like to conclude here and hand over the floor to our chair of the next panel, which I think is Professor Gleider Hernandez. Thank you so much.
Thank you very much, Stephan.